So good morning, everyone. I hope you can hear me well. The micro is more for the people who are following this event online. Thank you for being here. My name is Isabelle Doyon. I'm a French lawyer at DS Avocat here in Shanghai. And we will be presenting this data protection topic with my colleague, Beibei Zhang here. Okay, the purpose of this event was not to do another presentation on data protection laws and PIPL, because I think at the end of 2021, you have probably already attended a lot of events or seminars or information meetings about the new law, the PIPL and the data security law. So we take for granted that you have the general information on the legal framework already. What we really want to focus on this presentation is now the law is here, you have the list of the obligations you need to comply with, but where do you start and what do you start with? Because it's quite difficult to navigate in this regulatory framework. And sometimes when you have to start your compliance program, you don't know what you have to take into account and what are the key factors and the key issues you need to deal with. So the purpose of this presentation is really to try to guide you through this set of obligations that you have and try to help you to build your own compliance program. So of course you are from different backgrounds, so maybe some messages would make more sense for some of you than others, but the idea is that each of you can actually pick the general ideas of this compliance program. So first, I will leave the floor, because even though we're not going to go into too much details of the legal framework, we need to present you the big picture of it. So just to remind you what we're talking about and what's the regulatory framework. So I will give the floor to Beibei for that.
Hello, everyone. I believe that you have heard many times of the regulatory framework of data protection in previous years or especially last year, but I'm sorry that I need to briefly introduce the framework again. So as we all know that last year has been a very important year for data protection, especially for personal information protection. We all know that the data security law and personal information protection law, they become effective on September 1st and November 1st last year. With these laws, we all know that personal information protection obligation and data protection obligation were not new for companies because there are already provisions in criminal law, e-commerce law, and the law of protection of consumer rights, etc. in China. But with these two important laws, data security law and personal information protection law, they really changed the games how companies, they process data in China, especially related to personal information. Especially in recent years and last year, there were many national standards and guidelines were released by different authorities. They won't guide the companies to do the compliance. But companies, they know that there are strict obligations imposed on them, but there are still some uncertainties behind this legal framework. However, because compliance is a time-consuming and very complicated task for companies, it's a never-ending process. So we suggest that the companies start the compliance program as soon as possible, because in these national standards and guidelines, there are practical solutions provided for companies. So let's move to the next. The roadmap for data compliance. After the first page, I believe you all know the major laws to comply with, but do you know what's the target? How to reach the target? Which is the first aspect to work on? Does anyone has any clear role? So let's see how it works. In the cybersecurity law, data security law, and personal information protection law, there are many, many different obligations imposed on companies on data protection. And we can classify these obligations into three main blocks: the organizational block, human resource block, and finally the technical block. Although they fall into different blocks, but actually these obligations are correlated with each other, especially related to data protection and personal information. You can find similar requirements in CSL, the cybersecurity law, data security law, and personal information protection law. So these Chinese laws, major Chinese laws, they are to some extent correlate with each other. They are not contradictory, actually. For example, when we talk about organizational obligations, companies firstly need to have their internal rules to formulate and publicize processing rules on data, especially on personal information protection. I believe most of you, if you have a website or official WeChat public account or any mobile applications, you must have the privacy notice to your consumers. And when we talk about human resources, because most of the guests, you're from, I believe, European countries, you all know that for companies process big value of data, you need to appoint like a DPO. In China, in the three major laws, they all require that companies to appoint an O, the officer responsible for cybersecurity, the officer responsible for data security, and the officer for personal information protection. So maybe the name of the roles are to some extent different from the DPO under GDPR, but actually, to make it simple, you need to have someone internally to be responsible. Okay. Yes, yes.
Can we answer this question? I keep it in mind because that's you're right. It's a very important question. But if you don't mind, I will try to answer to it later on because we have a specific slide. We come back in details on this human resources aspect.
Because we will explain the roles for the different officers later on. So let's focus on the three main blocks. As you can see that in the organizational obligation, human resource obligation, and technical, to some extent, they are related to classification of data. And this is one of the most important aspects Isabella will introduce in the later stages of today's sharing. So let's see the second page. To do the data compliance, there are some important aspects that companies to really attach importance on them. The first one is, I hope you can see it clearly, it's resources, the top one. Because to do the data compliance, you're not to provide only some documentations, paperwork on the table. You need to make these papers work for you. You need to make your employees and sometimes external resources to be familiar with in your contracts, in your vendor management rules, something like that. So data compliance is a top-down measures. The management level to sometimes even the shareholder, the board level, they need to allocate some resources to different apartment and to give the due rights to do the data compliance. And the second important aspect is about data mapping. This concept is to some extent related to technical aspects. However, this is what we start with to do data compliance. Data mapping is to help the company to know the major or the main data flow inside the company, what is happening inside the company. And the third one is about training. I believe that some of the guests, you might know that in the recent 2 months, the Chinese authority, they released 2 important drafts regarding data, cross-border data transfer and security assessment. And they refer that companies, if they process a large amount of data, the management level of the company need to receive a minimum time, like 20 hours per year, about data protection. So training is really something that company need to provide regularly instead of to provide it only when some new laws were released. And the next one is about vendors, because you all have the clients, vendors. service suppliers, IT suppliers. So you need to audit your vendors to know their compliance level, and it need to reflect it in your contracts. And the second one, I think this is a hot topic today, cross-border data transfer.
We'll come back in detail.
Yeah, we will come
on
back
this topic.
details.
On all these topics, we're just introducing here briefly, and we'll come back in details on this.
Today we will talk about cross-border data transfer in detail. So you can write down your questions related to this topic. And the next one, I believe most of our European participants you're familiar with, the accountability. For Chinese participants, I will refer it as a documentation, because I believe for traditional Chinese companies, actually they are not familiar with documentation, the whole process of how they process data. They think that to some extent the contracts are important, but they will not keep the log of the whole process, how the company is receiving data, processes data, and in the end, whether they will delete the data after the cooperation. So now I think Chinese authorities, they are imposing a very similar regulatory obligation for companies as we have under GDPR. That's accountability. And the last one I will talk about is security. Because in China or in European countries, we all think that there are data leakage incidents happen, and there is no 100% security measures can be taken, but we can implement some effective measures to try to reach this goal. So in the next part, Isabella will introduce each of the aspects in detail. So write down your answers. Now I will leave the floor to Isabella, and she will provide the concrete steps companies can take to reach the data compliance.
Thank you, Bebe. All right, so let's come back in more details on all these different themes. So basically, as Bebe explained, you have three main blocks of obligations. Each block can be translated into several themes, which is this circle of around the data compliance. And each of these themes, if you take them into account, you're building your compliance program and you're moving forward to a good compliance internally. So the first one, I'm sorry, the top is cut, but I will just read it to you. It's allocate resources to support your program. That makes sense because, as Bebe said, the matter is quite complicated and you need to have human resources, but also budget allocated before you start your compliance program. And this is very important because, and we've seen it in Europe, a lot of companies wanted to do cheap compliance. Like, we're going to appoint someone within the company that has already a full-time job, and we're going to ask him to do the compliance program. So usually it doesn't work because it's not compatible with an already existing full-time job and the compliance aspect. It's already in itself a full-time job, depending on the size of your organization. So human resources is very important. Bebe told you about the three main laws we have composing the regulatory framework. So we have the cybersecurity law, the data security law, and the personal information protection law. Each of these laws designate roles related to data compliance. So in the CSL, we have the obligation to appoint a cybersecurity officer. Maybe some of your organization already have this role internally because the CSL entered in force in 2017. So it's not a new requirement. It's something that is already existing. The data security law, which is more recent, makes an obligation to processor who process important data, okay, to appoint a person in charge of data security, which we'll call a data protection officer, and a data security management body. So we talk here about the DPO. So just a warning message for my European colleagues. The DPO, we know it in Europe further to the GDPR. It's the data protection officer, but the one who is in charge of personal data, okay? In China, the DPO is actually the one in charge of security of data. Data that can be personal information or non-personal information. And important data is not necessarily personal information. It's any data that can endanger public security, national security, or public interest if it's leaked. So for this important data, if your organization process important data, they need to have a data security, a DPO, data protection officer, and a management body. Basically, the management body is going to work under the instructions of the data security officer, and it has several duties that are listed in the law. Some of them are, for example, study and propose major decisions related to data security or monitor data security risk. So this role is really about security of the data, all right? Now, the last one is personal information protection officer. This role is actually the equivalent of the DPO under GDPR, okay? And that role is the one resulting from the PIPL, the Personal Information Protection Law. So, your question, because we have only few information on the role of that PIPO for the moment. We know it's mandatory in certain situations. That's what the PIPL says. But it doesn't say which cases, doesn't give the elements of the threshold where you have to have a PIPO appointed. We have some clues in previous national standards. And if we refer to these national standards, we know that it's mandatory for companies whose main business involves the processing of personal information. So you could think of marketing agency, for example, most probably. And this criteria is also to combine with another criteria, which is if that company has more than 200 employees. So companies whose main business is the processing of personal information and who have more than 200 employees, they fall under the obligation to appoint a PIPO. Also, if your company processed for the past 12 months personal information of more than 1 million individuals, they need to appoint the PIPO. And the third one is if your company is processing sensitive personal information of more than 100,000 people, you need to appoint a PIPO. Sensitive personal information, it's personal information that can reveal elements such as your biometrics, your religion, your sexual orientations, any information which are so personal that if they were not handled in a proper way could really harm your rights to privacy and your freedom, okay? So these are the requirements for these three roles. What we don't know yet is whether or not the PIPO, for example, needs to be someone internally or someone, if it can be externalized. It's true that in Europe, we have the possibility to externalize the role of the DPO, PIPO, but I would say it mostly depends on the type of organization you have. If you have many processings of personal information, personally, I would not recommend to externalize the role of the PIPO. It's very difficult to reach a good compliance with someone who is doing it from externally, who doesn't know your internal process and the way the company operates. If you only have very few processings, then yes, you may contemplate to externalize this work. But we need to see if it would be possible under the Chinese, and I don't under the Chinese law. And for the moment, I don't think we have any information on one way or the other. Yeah. Well, I would say the management body, to me here, and the person in charge, I mean, to me, the requirements of the law makes it that, to me, it seems almost impossible to have this externalized, practically speaking. I don't see how it can work, really. Yeah. So these three roles, it could be the same person eventually. But as I said before, the topic is so dense, tense, and so complicated that it's very difficult to have one person that can have all the requirements to fit the needs of the law. So what we suggest, depending on the size of your organization, it's to have, and then I will come back to the budget part. You can think of a structure of your organization and have, for example, a data compliance team with one person officially appointed if you fall into the mandatory requirements. But this data compliance team can be composed of several persons with different backgrounds, legal, technical, HR, if you have a lot of employees, or someone from retail, if you're a B2C type of company. So you can think of different type of people to have in this team. But I think the pluridisciplinary aspect of this team is very interesting to have. And then, of course, this team is not working alone, because you need to have some information that comes back from the operations to the data compliance team so they can adjust the process and take the right decisions. But also they need to communicate with all the different key stakeholders within the company to implement the process, actually. So it's really, you know, a flow that must be continued between the data compliance team and the teams that are more on the operating fields, okay? And of course, if you have the chance to have a compliance officer internally, that helps. So that's for the human resources. The budget is also very important because eventually you're going to have to hire new positions within your company. So that's some budget you need to have to take into account. Interesting thing you should know, probably in Europe, companies were literally chasing people with the right profile to be a data protection officer. And it has been a very a battle for company, because at the time the requirement was there, only very few people had actually the knowledge to handle this type of subject. So it's been really difficult for some companies to find the right profile, because there were very few on the market. I see a lot, because I'm a lawyer and I'm specialized in this field. On my LinkedIn, a lot of companies looking for data protection officer these days. So it's a rush to this type of profile. So if you have a window to hire someone now, I would suggest that you do it quickly, because maybe the profiles on the market would be not so frequent in the coming months. You also need to have a budget to consult some external specialists, because whatever your team internally is, maybe at some point you're going to have to need the expertise of a technician, of IT person, or a legal person to help you on some aspect, to review contracts or this type of documentation. And also maybe you're going to need some budget to invest in solutions that are going to improve your data security. Maybe you need to review your tools, your IT infrastructure, or your tools, or the different IT solutions you have internally. And as Bebe said, training is very important for the compliance program. So you need also maybe to keep some budget for internal trainings that can be carried out by external consultants or Okay, so the human resource, that's probably the first pillar you need to put in place to build your compliance program. It's very important. You cannot conduct a compliance program if you do not have the human resources and the budget behind. Okay. The other important step is the data inventory and data mapping. When you start a compliance program, you need to know where you are, where you stand at the moment you start it. You need to have a full picture of what are your current processing, because you're not starting from scratch, and the law is new, but you have already done a lot of processing, or you already have a lot of processings in place. So you need to audit these processings to make them fit in the new regulatory framework. So you need to obtain a complete picture of the processings to know if you are processing important data, because we know that in the law, there are some specific requirements for important data, or if you are processing some sensitive personal information, there are specific requirements for this type of processing as well. So you need to know if you are processing sensitive personal information. By the way, I'm just telling you, you all have employees within your organizations. Sometimes we have family information on our employees. We can have date of birth of children. Personal information of minors under 14 years old in China is a sensitive personal information. So you might not realize, but if you have all the family members of your employee and including children under 14, that's sensitive personal information. So you might have to think twice, do I really need this information? Isn't it sufficient just to have the number of kids my employee has? Do I need to have the date of birth? Maybe not. So you don't need it, you don't keep it, all right? So, and then you would not fall into the requirements of sensitive personal information. The data mapping is also going to give you the source of the personal information. Where do I get this personal information from? Did I get it directly from the individual, or did I get it from a third party? Am I sure that this third party has the right to give me that personal information? Okay, so the source is very important to determine. And the destination, who I'm sending this personal information to? Are they different entities accessing this personal information, and where is it stored? So that actually aspect will allow you to have the all data flows. And it's very important to know, from the starting point where the data comes from, where it goes, where it's stored, because there are some requirements on the storage in a certain situation, okay? Are there any third parties involved in the data processing? Do I contract with vendors? We're going to talk about the vendors later. Do I have subcontractors that process personal information under my instructions on my behalf? I have some obligations here to take into account. So it's very important to know if third parties are involved in your data processing. Cross-border data transfer, as Bebe said, is a very hot topic, especially for European companies having subsidiary here in China. So it's very important to know if you have personal information or data crossing the border from China to an overseas country, because we will see in detail that there are some requirements. So you need to have that in your mapping as well. Another important point as well is the retention period. You're not supposed to keep the personal information forever. So you need to set some retention period, okay? So this mapping will allow you to analyze your processing and see what's the gap you need to jump to be compliant, and what are the remedial actions you need to take. So basically, when you have your list of processing, then you're going to examine them in detail and see if you have a legal basis for each of these processing. We know now that under PIPL, there are several legal bases possible, not only the consent, as it was the case before, but contract is a possible legal basis. HR management purpose is a possible legal basis. There are other legal bases than the consent now in the law. Do you comply with the prior information requirements? So prior to processing personal information, do you give the right information to the individual you are getting the personal information from? That's one thing you will need to look at. If your processing is based on consent, do you comply with the consent requirements? What you have to put in place to make sure that your consent is valid. And of course, if your data mapping raises the fact that you have third parties involved, you need to make sure you have a contract with these third parties, and you need to make sure that the security measures are in a good form and comply with the requirements of the law. So the data mapping is very important. It's your starting point of the compliance program. You cannot start a compliance program if you do not have the full picture and the vision of your current processings. The vendors. So as we said, oh, sorry, you cannot see the title. Assess your vendors. That's the title of the slide. So as we said, in some cases, and it happens quite frequently, actually, when you think about it, even your IT solutions mostly are provided by an external vendors. So in this situation, you need to assess your vendors. So just to come back to what the law says, there are key definitions in the PIPL. One is the personal information processor or handler. So it's the equivalent of in GDPR of the data controller, okay? And the entrusted processor, which is your vendor. In GDPR, it's called the data processor. It's quite confusing because in Europe, the data processor is the data processor in China, but I don't want to confuse you too much. So I will stick to the Chinese terminology of the law, okay? So the personal information processor and the entrusted processor. So the personal information processor is really the entity that determines the why. That means the handling purposes. Why am I processing personal information? And how I am processing this personal information. So it's really the organization, the entity that controls the processings. It can be several entities that jointly control the processing. In that case, we're talking about joint controllership. But in most scenarios, it would be one organization. And the entrusted processor is the party that is entrusted by the controller to handle on its behalf personal information, okay? So this party, the entrusted processor, does not have any control. The control comes from here. The entrusted processor is just following the strict instructions of the controller. He's not supposed to do anything or to process the data in a way that is not decided by the controller. And that's very important because to make sure that your entrusted processor complies with your instructions, you need to formalize this in a contract, okay? That's what we call a data processing agreement. So you're going to pick an entrusted processor, but you are at a stage where you are running your own data compliance program and you want to make sure that your weak point is not going to come from that party here that is going to challenge your compliance, actually, your internal compliance. So you need to assess your vendors. That's very important. It seems to be quite long and complicated, but it can be through, questions, random questions. Do you have internal training for your team on personal information? What are the data security measures you're taking for the security of the data? This type of questions. And based on the response of your vendors, you will be able to assert and to assess his knowledge on data compliance. Okay? And that's a very important step to do before you hire your processor. Once you have, sorry, yes.
Like they were asking companies to do some regular assessment, right?
Yeah, it's not the same assessment as I'm talking here, but
okay. But for this one, because I couldn't see any, like they don't give any guidelines or example,
you're right? It's not mandatory in the law.
Okay.
It's more like a recommendation, something I would recommend you to do, because if you don't go through this step and you formalize a contract directly, you take the risk that even though you have a super compliance program internally and you have done everything internally you needed to do to be compliant, then your vendor is the weak point, and that's the one who can bring you the trouble, actually. It happened in a lot of cases in Europe for some controllers, actually, yeah.
So how do we get those guidelines?
It's more an internal document that you can put in place yourself. From my experience, because I used to work as an in-house counsel for an international company in Europe at the time of GDPR, and we had worked on a questionnaire at first that was very security oriented, okay, in terms of what are the security measures. And then we added a layer of more general requirements to be compliant, like what are your internal rules on data processing? Do you have trainings for your staff internally? These type of questions. And then you can ask a question, what are the retention period of the data? So it's really for you to build your own questionnaire. There is no specific guidelines on the topic for the moment, yeah. And you're right, it's not a step that is mentioned at all in the law, yeah. So the data processing agreement is going to describe the processing that you are requesting the entrusted processor to do. And it must detail the purpose, the handling method, the categories of data, the protection measures, and the obligation and the liability of each company, yeah. So the question is, shall we do this for the accounting firms or the company you are using for the payroll, for example? Yes, yes, I would suggest. And I'm sorry if you're one of these actors in the room, but you're going to see probably a lot of questions from your clients. But it's a good exercise when you are a subcontractor to have to go through this type of assessment, because it's actually also building your own compliance, and it gives you a good advantage compared to your competitors on the market. So the more compliant you are as an entrusted processor, the more you are, I mean, you are in a better shape in the competition with your competitors, because at the end, the controller between two processors is probably going to pick the one that is not going to bring him troubles, really. So we've seen a lot of big, the big software editors, they have done this work of compliance. They were the first to do it because it was very important for them to give the message to their client that they were compliant. And it, allows to raise the trust that a client can have towards these vendors. And at last, audit your vendors on a regular basis. It's important because the situation can be a situation at a certain at the time of signature of the agreement, but you need to make sure that this compliance level is staying the same within the duration of the contract. Okay.
Can the personal information handler shift its liabilities to the entrusted processor, and if yes, to which extent?
Okay, he will still be responsible to the individuals, but you can have a contractual liability that if the breach comes from your vendor, yes, you can actually have a claim against your vendor. But at the end, very often, you are the controller, so the risk for the image, it's you actually who is going to carry it. So I would say that your risk is more in terms of image to your clients or consumers, if you are a B2C brand, rather than the financial risk, really. Well, it depends what's the size of your company, because we're not going to talk about penalties here, but it's true that with PIPL, the level of penalties is very high now. It can be 5% of your annual turnover as a group, so it's very important. But the risk here is really in terms of image. So I'm just going to take an example of what happened in France that was quite a long time ago, maybe 10 years ago. Orange, okay, who is a big telecom provider, maybe #1 in France. It's also present in China, I think. They had a major security breach. That was not their fact. It was the fact of one of their subcontractors. But at the end, their image was impacted to the public, and they were recognized responsible. So they had, of course, in the contract, or I think at that time, they didn't even have a contract. They had a contract with their subcontractors, but not to solve this aspect on data protection. It was prior to GDPR, actually. It was several years before. But yeah. Okay, sorry, I keep the suspense. What is it? This is cross-border data transfer, so the very hot topic for for the European companies here in China, because most of you probably have so your headquarters outside of China in Europe, and at some extent you necessarily transfer some data, personal information to the headquarters. So there are some specific requirements under Chinese law, but it's fair. It's just like under the European law, GDPR, there are some specific requirements to transfer personal information outside of Europe. So it's just the same. We are in the situation now where we put the American companies and the Chinese companies towards Europe in the same situation when the GDPR entered in force in 2018. So nothing new. So there are several conditions to cross-border data transfers. First, there is a very important preliminary requirement. It's the necessity and the business need. Do I really need to transfer the data outside of China? So you can challenge sometimes your headquarters and really, what's the need? What's the necessity? Why do you need the personal information of my Chinese consumers? Why does it make sense? So really ask yourself the question, because if you realize that there is no business need and no necessity, that it was just an habit until now, you can cut this habit if it was a bad habit, and then you would solve yourself a lot of troubles, actually. So business need necessity is number one preliminary requirement. Number two, you need to have the specific consent of the individual you are transferring the personal information abroad. So that's more difficult to comply with. So basically, at the time you collect the personal information, you need to give the information to the individual that you are going to transfer his personal information outside of China, explaining who you are going to transfer the information to and why, and how that entity is going to use them. And you need to get the consent, and the consent needs to be specific. So that means you need really to point out the fact that you are transferring the personal information outside of China.
If the data is anonymized and de-identified, do we still need to ask for the consent?
If the data is de-identified, but really that cannot be reversed, okay, you do not fall under the scope of PIPL, okay? So you don't have to have the specific consent of the individual because it's no longer personal information, okay? And also prior to do the cross-border data transfer, you have an assessment to do, which is the personal information protection impact assessment. I will come back later on that assessment when we discuss the accountability and documentation. Then, once you have it, you need to select a transfer tool, meaning that your transfer must be framed by a legal tool. In some scenarios, you don't have a choice. You have to go through the security assessment organized by the Cybersecurity Administration of China, okay? It is mandatory if you are a critical information infrastructure operator, a CIO, and you handle important data and personal information, or if you are a processor handling important data, or if you export sensitive personal information of more than 10,000 people, or if you export personal information of more than 100,000 people, or if you are a processor of more than 1 million personal information of more than 1 million people. For these scenarios, you have a local storage requirement and you need to go through the security assessment. That's mandatory. As Bebe mentioned before, we have 2 draft measures that were released in October and November 2021 that are giving us a little bit more details on how this security assessment is going to be conducted. Hopefully, these measures should be final and effective, hopefully maybe the first trimester by March or April this year. And so it will clarify this aspect. Another tool that can be selected is a certification, but in my opinion, it's not gonna be possible before several months because there is currently no certification in China. Just to give you an idea, in Europe, GDPR is effective since 2018. There is no certification at a European level yet. So it takes some time, this type of certification. So mostly, what's going to happen for the moment, if you do not fall in this scenario, is that you're going to use a contract with the overseas entity. And that's going to be your legal tool to transfer the personal information. So this contract, you need to stipulate the rights and obligation of both parties. You need to describe the data that is transferred. And it's a little bit built like a data processing agreement. So you need to describe the processing, the type of data, the categories, the person concerned. That's our recommendations. The PIPL say that the contract must fit with a certain template. We do not have any template communicated by the authorities for the moment. So we have to start working on something anyway, because we cannot just do nothing. And but we know that the Chinese regulator is looking very closely of what's happening in Europe and what the European regulator is doing. And recently, last July, the European Commission released new standard contractual clauses, which is the equivalent of these, that you must use when you transfer personal information outside of Europe. And we can feel that the requirements are going to be more or less the same. Okay, so that's for the cross-border data transfer. Another theme we've seen in the circle of data compliance is the accountability and documentation. So the laws, the three laws that we've seen at the very beginning of the presentation, list several documents that you need to work on as an organization processing data. So first, a data controller, data processor, has a very important obligation according to the law, which is the obligation to inform the persons of how they are processing the personal information. So you need to inform your employees, like you need to inform your clients or prospects. So internally, companies have to inform the employees of the type of processing they are making of their personal information. So that can be done in the employee handbook, okay, where the company explains what they collect, what's the purpose, what are the security measures, who have access to that personal information, etc. Internal rules also remind the basic obligations in terms of data protection, and the IT charter as well. You can insert in your IT charter some obligations for the employees to comply with, so to have a good data security level. So, for example, can be do not leave your password on a post-it on your desk. This type of measures. We all do it. No. Just kidding. But you know, this type of rules, you all have, or you all know the IT charter. You certainly have some already internally. If you have a website, a WeChat official account, mini program, if you communicate or process personal information of clients, you know, if you are a brand or a retail company, you also need to review your privacy policy to comply with the requirements of the law and make sure you give the full information to the individuals. So that, I would say, is documents you need to have more for, you know, information purposes to your employee or clients. Internally, you need to have a data subject rights process. So PIPL gives a lot of rights to the individuals you are processing the data from, meaning that anyone, a client of a store or a brand, can ask the brand, oh, what are the personal information you have on me? Can I have access to it? Can I have a copy of all the personal information you have on me? Can I correct my personal information, or I want you to delete my personal information? So when you get a request like that from a consumer, it can be very hard to manage and to handle. So you need to have a process to make sure that you are going, if the consumer wants his personal information, for example, deleted, you need to make sure that you are going to delete, like, you know, across all the different softwares or database you have internally. If you are working a lot in the silos, you need to make sure that you are checking each silos that do not necessarily communicate between them. So you need to put in place some process and have someone appointed to make sure that the right response is given to the data subject. Because you have a time frame to respond to the data subject. It's 15 days in China. It's 30 days in Europe. It's 15 working days in China. It's very short. And if you do not reply, you can have an individual or data subject that becomes very angry to you and can go very fast on the social media, you know. So that must be handled very carefully, okay? Other documentations we mentioned briefly before, it's the risk self-assessment report, which is necessary when you process important data or when you transfer personal information that comes under the security assessment. So basically, when you are going to request the security assessment from the CAC, you need to present in the documentation you're giving to the authorities the risk self-assessment report that you have conducted internally before, okay? The measures give us some ideas of the draft measures give us some ideas of what the risk self-assessment needs to contain. It's more, you know, it's a, yeah, I would say it's a basic risk self-assessment or data security assessment. So you need to make sure, you need to describe the type of data, the security measures, you know, it's always around the same questions and topic. And so is also the personal information protection impact assessment, which is a requirement of the PIPL, and it's mandatory in a certain situation when you are processing sensitive personal information, when you are using personal information in automated decision making, that's profiling, when you are contracting the processing of personal information to another party, so to your vendor, or where you transfer the personal information to another party who is going to process this personal information for their own means, okay? Or, of course, when you are also transferring the personal information overseas. So this is the equivalent of what we have under GDPR as a privacy impact assessment, PIA. So it's a documentation where you are supposed to give the full picture of the processing, and make sure that it's compliant with the requirements of the law and the data security measures, etc. So there are many, and this one, sorry. Personal information protection impact assessment, you must keep it internally for at least 3 years, okay? And if, of course, there is any change in the processing during, you know, in the time, you need to reassess the processing and make sure that the changes do not impact the legality of your processing. So these documents need to be reevaluated on a regular basis whenever there is a change. Okay, last part we've seen on the data compliance circle is about the security measures. So really, data compliance, data protection have a lot to do with security, because at the end of the day, what we want to is to prevent any unauthorized access to or leakage of or tampering with or loss of personal information. So the security measures are really there for that. Security measures, we have, you know, it's not new. There are some requirements dating back from the CSL. Encryption, de-identification of data is also a very important security measures. Data security education, meaning training internally, is very important. Reasonable users' right design, so don't give access to client's database to anyone or everyone within your organization, so just manage the access rights. And two very important, which are related to security measures, is the contingency plan and the data breach procedure. So the data breach procedure is a requirement, and the contingency plan is a requirement from the law as well. So the contingency plan, it's the ability to prepare to the worst, and we know that the worst can happen. But when it happens, it's to be able to respond and to recover. So if you have a data breach within your organization, the idea of the contingency plan should allow you not to stop your operations, but to continue to operate on maybe a mode dégradé, but you would not have to stop all your operation. So these are very important for a company to have internally, and it's mandatory, but that's for the sake of your business. I don't want to run out of time, so I want to leave room for questions if you have. So I will conclude. So as you understand, data compliance is a long journey, and it's not a walk in the park. It's not an easy task. It takes time. It takes resources. It's difficult. So you need to have a method, and you need to have patience. You will never, I can tell you today, achieve 100% compliance. That's not possible because the regulatory framework evolves, your processing evolves. So you always need, it's like an ongoing matter. You always need to reassess. You always need to review your compliance, etc. So you do not reach 100% compliance one day and say, okay, I'm done. That's it. No, it cannot be that way. So also, a compliance program must be driven by top management. It's very important that you embark the top management in your compliance program. If the top management is not convinced, and they're not going to give you the resources first to conduct the program, and they're not going to support it. And really, a compliance is really a top-down matter. So it has to involve the top management. And it's the matter of everyone within the organization, not only the topic of the compliance team. A good compliance can be achieved only if everyone within the organization feels empowered and feels responsible for the compliance of the organization. That's why the training is very important, okay? Because as we've seen, the key points can come from your vendors, but it can also come from an employee that does something that is not compliant. So it's very important that everyone feels concerned. And questions? If you have some questions, we still have time. Sorry, we're just on time.
Yeah, I have a question regarding the transfer tools.
Yeah.
Just in your previous slide, you mentioned that actually that's quite 4 main steps, but the relationship between them is like or, it's not and.
Yes.
Right? Okay.
Yes, it's or.
Okay.
So you need to choose one of these. I mean, you choose, sometimes you don't have the choice, but it's one of these two.
One of these.
Yeah,
Okay,
exactly.
thank you.
Yeah.
Sorry, on the same slide, I just want to know the hiding components of the maintaintory just below of the local storage.
Oh, there is nothing left here.
Ah, okay. And
so you have the local storage requirements in this case, in this scenario, and the security assessment is mandatory for these 5 situations here. Yeah.
And
Yeah.
sorry, still question. If I have all the data compliance assessment and all the backup to the supervisory authority, and then I do the data cross-border transfer to the headquarters, for example.
Yeah.
And if I want to do the, for example, precise marketing, I want to send the targeted audience messages to the Chinese customer, because there is a retention period, right?
Yes.
Can we postpone the retention period, or do we necessary to redo again the?
Okay, so there are 2 topics, I think, in your question. The targeting marketing is done by the Chinese entity towards its Chinese consumers, right? Or it has nothing to do with the data transfer. Because it's 2 processing for me with 2 different purposes. So it's important when you do your data mapping and your inventory that you really examine each processing separately. So you might have data transfer, that's one processing. The transfer is the processing. The targeting for marketing purposes in China of your Chinese consumer, it's another processing, okay? The retention period, there is no fixed periods in the law. There is just a general requirement that the retention period, you're not supposed to keep the personal information for a longer time than what is actually necessary for you to fulfill the purpose of the processing, okay? Marketing targeting, usually you think it's reasonable, you keep the data, your personal information of the individual if he's your consumer, creates an account on your website or, I don't know, is your client. So there is no reason why you would delete his personal information. However, you can set retention period also for yourself, saying that after, for example, 3 years of inaction from this consumer with my brand, why do I keep the personal information of that individual? He's not interacting with my brand anymore. He's not receiving the newsletter anymore. I haven't seen him in store. He didn't buy anything. So there is no reason really why you should keep his personal information. And for yourself, you know, having a lot of personal information in a database, it's also an additional cost. You are better narrow and focus on the personal information that has value for you rather than quantity, really. So it's, I think all these laws and regulations teach us a very important message, is that quality of the data is more important than the quantity, because quantity gives you trouble, actually.
Thanks.
My question is, what is the expected time frame to have all of this done by? I mean, the laws were passed already. Is it?
Okay, I don't know if I can respond for the Chinese authorities. I know that in Europe, we've seen there has been, you know, some time before the regulators in different countries started to really implement hard punishments on companies that were not compliant. When they started to do it, they did it against the big ones, the GAFA, which were actually the targets really of the regulation in Europe. In China, we've seen that similarly, the giant tech are the ones that are being hardly targeted by the authorities recently. But, you know, if you have an obvious misconduct and unlawful type of processings and you're a small company, I think you can be in the target as well. If you are reasonable, you know, reasonable on your processing, and that you still need to work on the documentation, the internal process, and that you show to the authorities, if you have a control, that you have something started. Of course, you know, the law was adopted end of August and effective beginning of November. That's 3 months. It's just impossible to achieve a compliance program in 3 months. It's going to take months and maybe sometimes years on some aspects. But if you show that you have started something, that the topic is taken internally into account, that's a good sign to send to the authority. And I think they would be more, you know, flexible with you. Yeah.
And sorry, just on that point then, again, it's very opinionated, but is there a particular priority to focus on first? For example, should we be looking at our internal processing and procedures, or if we have external transfer of data, is that more of the hot part? Is there anything that you would suggest?
So that the prioritization is very important, and that going to come after you do your data mapping and inventory. Because as I said, in your data mapping, you're going to see where are your cross-border data transfer. So that's, you know, red flag that is going to raise. You see if you process sensitive personal information, that's another red flag, and important data, another red flag, I would say. So, and of course, maybe the volume of source data can be a criteria you're going to use, because you take more risk if your security measures are not compliant on a higher volume of data than on a lower volume. So that can be a criteria to prioritize your actions as well. But you're right, I did not mention that in my presentation, but after the data mapping and inventory, you need to prioritize, because it's difficult to do everything at the same time. Yeah. And your internal process, like the employee handbook, privacy policies, this is very, it's a quick win. It's something you can do very easily and very quickly. It's not so maybe that's quick wins. It's something you can also do at first because it's easy to do and allows you to achieve some compliance quickly. Yeah.
We received a question online, just quick. The person was asking what will be the impact of the PIPL for a company who is making some retails and who need to make a cross-border transfer of data, for example, of the sales database or this kind of case. Well, what are your advice as well for preparing
So I don't know if in this question there are necessarily personal information or if it's just sales figures. If it's just sales figures not attached to an individual, then you don't really have the trouble of the PIPL. If it's personal information of who put something in your store in China, then I think the first question you need to ask yourself, business need, necessity. Why do I need to transfer this information to the headquarters? I mean, they can have aggregated figures and not know specifically who is the individual who bought something in my store. So really, comes back again to the first question you need to ask yourself, business need, necessity. And business need question is not only for the cross-border data transfer, but generally speaking, when I collect data, do I need to collect all the data I am collecting, or can I just focus on some data? Really having this question in mind all the time is going to save you a lot of troubles and a lot of time. So narrow as much as possible the data you're going to process and always, always relate to a business need and a necessity. I hope it's giving an answer to the question.
Another example, if we do minute of meetings, about some meetings with some person here, which share his own thoughts or his own opinion that we relay on the minutes and we share outside. Is it something also tricky?
Opinion or business cards? Contacts? No, just opinion. No. Someone tells you something during a meeting, a random meeting, external. Yes.
And we write it down on the minutes that he believes, so he thinks that this is related to him, that he may be considered as sensitive. I don't know. That's the question.
Well, unless the minutes reveal some sensitive personal information, but I don't see, never met this case, but comes back to the legal basis of the processing. Do you want to answer that one? Or?
Yes, I want to mention that
there's one legal basis interesting maybe for this case.
Yeah, because I think your question is related to not only personal information or data, it's to some extent may related to privacy. Because we didn't mention today that in China we have the PRC Civil Code, and under the Civil Code we have the protection of personal information and personal privacy. Yeah. So now privacy is legally protected. We have some, according to our experience, we have some clients, they will send their engineers into their client's site to do some technical maintenance or provide some on-site after-sales services. And during this process, the technician, just like your question, they will write down something happened on the day. They need to write down who they might contact, what's his name, sometimes full name, telephone number, and even the address, because for the client, they have different sites. And what happened on the day. For example, what questions did the client ask? And sometimes they will even write down, some incidents or matters happened on the day, which is not directly related to their daily activity, but they believe this kind of, client preference can help them to improve their services. But please do pay attention to this kind of notes or minutes that is not related to their personal privacy, and do not extensively or excessively record what the company does not need to know. So I think that's the points I want to add. Yeah.
Thank you. Okay, my question is, I remember one slide saying the weak point can come from your vendors. From your experience, normally how companies are managing their to assess the vendors.
Can you repeat? How long does it take to assess? No?
From your experience, how companies are assessing their vendors to avoid?
Okay, I can share my experience with you. So the way we used to do it, in my previous company, we had a purchase team, okay, département achat in a French company, that had a grill actually already set in place to select vendors, different vendors. I think most of the big international groups probably have this, and they have several criteria, the price, of course, and the structure of the company, et cetera, et cetera. So we just integrated the privacy, the data protection requirements in that grid. So it participated to the global note that the vendor would have after the assessment, which was a more global assessment. And the basically what we did, we had an Excel sheet with like, I think it was 120 questions. That was their long version. We had a shorter version, 20 questions. So depending on the size of the vendors, you can adjust the questionnaire. But as I said, there were one big part related to data security and the security measures taken by the vendors. And that was drafted by our IT person, the person in charge of security within the company I was working with. And then it was more question about general compliance, internal trainings, the internal rules, the privacy policy of the company. You can ask the question, have you ever had any warning from the regulators on data processing or this type of questions? So it can be yes, no questions, or open questions. The idea at the end behind the questions you're asking is really to know what's important to you, and the responses need to allow you to assess and to have an idea of the maturity and the level of compliance of your vendors. So that's the key objective to have in mind. Okay.
Sorry, many question. Take the opportunity. Does a copy of a passport are basically personal data?
Yes,
because
it is.
This is shared by the travel agency.
Yeah.
Accounting, FESCO,
Right.
social charge. It can be a mess to go to this agreement to all the suppliers.
So it is a personal information because obviously you have a lot of information, your date of birth, your nationality, etc., your picture. It's though a personal information. It's not because it's a public information that or that you give that it's not does not need to be protected anymore. The thing is that if someone is giving you, like an employee, a copy of its passport for the I don't know, to carry out the formalities of visa, because the company is going to take in charge the visa applications of the employee, etc. Okay, fine. You expect the company to use your passport for that purpose. What you would not expect is that a company is transferring the copy of your passport to a marketing agency who is going to target you for some products thereafter. That's not a normal use. So whenever you are processing personal information, always put yourselves in the shoes of the individual that is giving you the personal information. Does that individual expect me to process the personal information in that way? And that also is linked with the information obligation. You inform the individual how you're going to use the personal information. So he expects you to use the personal information according to that information he gave you. If you're using the personal information in a different way, in a different manner, you need to inform that individual again. Or if you don't, then the processing is not compliant, I would say. Okay.
Passport and and for example, FESCO has all this data. We must have a kind of agreement, as you mentioned, to protect.
Why Facebook would have all the what's the link between the travel agency and Facebook?
Not Facebook, FESCO.
Oh, okay,
The
sorry.
payroll,
Oh, okay, sorry.
which pay all these staff who have a lot of data. I guess this company can be attracted by a lot of marketing to ask for some data. I don't know.
Well, the thing is that as long as they process the personal information in a way that was not the information they gave to the individual, they are out of the process. They are not compliant anymore. So it's all a matter of information, the information I give to the individual. And really to stick to the processing, I give the information to the individual on, okay?
Who is liable?
Well, they are the ones who transfer, the person who transfer the personal information to another party for another processing without informing the individual in a way that is not compliant with the processing he mentioned he would do. He is responsible. Yeah, the receiver of the personal information, like we said in the data mapping, you need to look at the source of the personal information. Where did I get the personal information from? Did I get it from the individual directly, or did I get from a third party? If I got it from a third party, am I sure that this third party was supposed to give it to me? So that's something you can check as a receiver. But the person who gave you the information and was not supposed to give it to you is responsible also. So you have, I would say, a duty to know the source of the personal information you collect, but the responsible person is also the one who transferred the personal information to you. I'm not sure to...
We are a company and we have to deal with those outsourcing company, accounting, travel agency, and so on.
Yeah.
If they don't
So you are the controller.
Right.
You tell
the
them
so
how you want them to process the personal information, and they need to stick to the instructions you give them.
And your recommendation is to do audits regularly to them?
Yes.
And
have a contract anyway, and in the contract, you tell them how they are supposed to use the personal information. If they are out of the scope of the contract, they are in breach of the contract.
Just one last question, and then we're going to conclude.
So in Europe, I am a certified DPO and CSO. And what about in China? What are the requirements to hire a DPO or CSO inside an organization?
I would say if you are certified DPO under GDPR, you are a high value resource in China.
So I'm free.
Certification of DPO in China, I don't even think the topic has been open yet.
But it's a EU GDPR certification.
Yeah. My colleague, Bebe, is a Chinese lawyer specialized in Chinese law, and she just passed the, it's not the certification, but it's an exam, you know, the acknowledging her competence and knowledge on the GDPR. So I'm sure probably for DPO, but I don't think it's open yet. But you can train yourself on the Chinese law, and you will see that it's going to be very easy for you with a good specialist at GDPR.
I didn't notice any major difference. So
no,
little
exactly.
differences out there
on the legal basis, a little bit, but it's going to be very easy for you to convert your expertise under GDPR and in Chinese law. It's so you are a good candidate for internal DPO for a Chinese company.
I'm free. Okay.
Thank you very much.
Thank you all.
And Isabelle, I guess some people may still have some questions, but in fact, well, there's still the breakfast at the entrance. So if you want to ask Isabelle or Bebe your questions, feel free. As well as for our online participants, thanks for joining us today. We will share later the presentation by email and also share the contact of Bebe, Isabelle, if you need to contact them or have further questions. Thank you very much, everyone, and have a good day.